Okay, Assalamualaikum warahmatullahi wabarakatuh. This is a recorded lecture on nuisance. This is part two, which is a continuation of part one. So part one basically covers public nuisance. So now is part two. Private nuisance discussion is quite somehow lengthy. So there are at least two or three parts here of this recorded lecture. So let us start with the first part of private nuisance. As you can see on the screen, okay, it defines the word private nuisance. Actually, we have touched this in part one, okay, during the introduction. So, what does it mean by the word private nuisance here? So, again, this is to recap or refresh. It refers to unlawful interference with what? With a person's use or enjoyment of land or some right over or in connection with it. And then again, when we talk about the act here, okay, the act of defendant or interference here, maybe, okay, the act here may not be inherently unlawful. For example, singing, okay, loud voice, for example. So maybe it's not really unlawful. But what if it in what situation it amounts to nuisance here, okay? Whenever it interferes, okay, with plaintiff enjoyment of the land. Defendants act here, all right? It interferes, okay? It amounts to interference with the plaintiff enjoyment of land over which he has possession. Plaintiff has possession over the land. So, in order for the plaintiff to be able to sue defendant in that situation, plaintiff must have interest in the land. So, he has the locus standi, the right or the legal right or legal position to sue under this tortious action of private nuisance. Okay, let's move forward. All right. So when we talk about private nuisance here, okay, there are three types of interference. The first one, encroachment. Okay, from the encroachment on plaintiff land. The second one, physical damage to plaintiff lands or property. And the third one, disturbance of plaintiff's comfort and enjoyment of land. If you refresh, okay, the previous topic that we have covered together, for trespass to land, actually, it is overlapping with nuisance, especially the first two types of interference here. Encroachment of plaintiff land is also trespass to land. It's also a nuisance. It's also private nuisance, or even physical damage to plaintiff land or property. It is trespass to land, and it's also nuisance. But the third one, okay, the third one is usually it is very common types of interference for nuisance. It is about disturbance of comfort and enjoyment of land. So maybe it's not really trespass to land, but it could be solely due to private nuisance. Okay, we have two important elements of private nuisance. Of course, it's different compared to public nuisance. First element that must be fulfilled, there must be substantial interference. It cannot be any interference. It has to be interference with which is substantial. So under this particular element, okay, we have further explanation relating to the types. Okay, amenity nuisance or physical damage. It depends on the nature of the interference here. And then the second important element that must be fulfilled together is unreasonableness, or interference is unreasonable. So what is the factors to say, or what is the guide here? So we have a list of factors depending on the scenario. Maybe we have altogether 5 here. So maybe one is relevant, the rest are not relevant to that particular scenario, but that particular specific case here. So the first one, extent of harm and nature of locality. The second one, defendant's utility. And the third one, abnormal sensitivity. For the fourth one, temporary injury. And the last one is malicious intention. So I think for this particular part of lecture, we are going to cover the first one. Because we have a number of slides to cover for substantial interference, and then we are going to discuss unreasonableness up to extent of harm and nature of locality. And defendant's utility will be covered by part 3 of this recorded lecture. Okay, let us move forward. Okay, what is meant by the word substantial interference here? Remember, okay, nuisance is not actionable per se. I mean, the moment it happens, you cannot really take action unless you prove there is any damage. In order to prove damage, okay, you have to convince the court, or you must fulfill element of substantial interference. So, on the part of plaintiff, okay, must prove damage here, okay, elements of injury or losses suffered. It could be physical harm, okay, which is tangible, or even disturbance to enjoyment of land, which is intangible. You feel it, okay, but then you cannot really, I mean, it's not really something which is tangible in nature, okay, tangible versus intangible. Both actually are damage, which is I mean, recognized, okay, under nuisance here. So in terms of categories or classification, we have this amenity nuisance and material or physical damage. So amenity nuisance here, usually it means interference with the use or comfort. I mean, you don't feel comfortable, all right, because of this nuisance. Comfort or enjoyment of the land. And because of that, okay, the plaintiff is unable to live peacefully on his own land. But again, it cannot be trivial. It cannot be something which is so little or too trivial. Okay, here. That's why we have the rule relating to substantial interference here. And of course, another kind of damage is material or physical damage, tangible here, right? To land or property. Okay, let's have a look at the case. I think we discussed the case in some of the previous topics, especially task one, I believe. Okay. All right. So we are going to again use the same case. Rina Link, KL, Kuala Lumpur, Sdn Bhd and Datuk Dr. Harnam Singh. Obviously it involves neighbors here. Okay. All right, so plaintiff, you can see, I mean, the summary in the picture there, because one picture tell thousand stories. So, it's easy to understand seeing I mean, by looking at the picture here. All right, plaintiff had, I mean, both of parties here have clinic. So plaintiff had for 18 years, he operated a clinic and hospital for the treatment of ENT, ear, nose, throat here. Okay, plaintiff, lower floor, all right, the lower floor, all right? Sorry, and the defendant operated renal clinic and which patients receive hemodialysis on the floor above the plaintiff clinic. So plaintiff is below and defendant is above, all right? So the defendant was found liable. I mean, plaintiff brought a case against defendant. So defendant was found liable for emitting, discharging from their clinic obnoxious fume, and this fume escaped downwards, into plaintiff clinic. So plaintiff suffered from this damage. Plaintiff staff and patients were found to have suffered substantial damage, including skin disease. So it is very substantial in nature here. So at the lower court, plaintiff won the case, but the appellants or defendant appeal against this decision. Okay, and this is argument, okay, on the part of appellant or defendant here. This is argument by the counsel. So counsel for the defendant argued that, I mean, on the totality of the evidence, okay, counsel said that there was absence of any connection in point of causation. I mean, because the case is also on causation, okay, here between the appellant and the noxious fume that had invaded the respondent's premises. Because why? Counsel suggested that, oh, there had been some other possible sources, okay, and then therefore, okay, I mean, the case should be resolved in the appellant's favor. I mean, appellant or defendant should win the case. But counsel for the respondent or plaintiff argued that, well, when we brought the case in the court below, okay, I mean, there's no issue at all about possibility or existence of another source of noxious fume in question. Actually, when the case went up to appeal, the counsel or the party cannot cannot introduce new argument or new cause of action actually here. Okay, everything must be settled at the lower court because they talk about the whatever evidence, okay, will be done at the lower court. All right. So because of that, okay, the court dismissed the appeal. Because why? The court held that the issue of another possible source of the noxious fume was rightly not considered by the learned trial judge, the lower court, okay, and was not addressed before her at the court below. So it's not fair that you brought another or new cause of action altogether, okay, during the appeal stage here. All right. So, plaintiff won the case. All right, we have another case. This is example of nuisance by way of noise. Okay, just now by fumes. Okay, right. So here, this is appeal case as well. The case name is Syarikat Perniagaan Selangor Sdn Bhd and Fahrul Rozi Muhdi and others, 1981. Okay, here respondents they sued the appellants to prevent it from using the land, okay, from using its land so as to cause annoyance, okay, annoyance by what? By noise to the neighboring landowners. Actually, it involves certain stage and disco, okay, disco generator for discotheque. That's the full term or the full name for this school. So they apply for injunction to restrain the appellants or its servant from operating or permitting to operate music bands with singers from open air stages. I mean, it causes lots of noise here, okay? And also to restrain, okay, from operating generator for the discotheque on its land until the trial of the action of until further notice. So they ask for injunction for the things to stop. So what happened next? All right. So yes, the court agreed to give injunction. The learned trial judge granted the injunction and the appellant appealed. At the appeal stage, okay, they still lost the case. Okay, I mean the appeal was dismissed, and it was held that the learned trial judge was entitled on the evidence. Okay, based on the evidence produced, to find the finding was that the noise was so excessive and intolerable, and yes, it is actionable nuisance. And because of that, yes, I mean the court allowed the injunction here. Respondents were entitled to the injunction. But the most important part of this case is this part. All right. The court actually explain, okay, or we can extract the rule from this particular judgment, okay. This is a quotation. The court actually try to give analogy here, all right. The court said that here, noise in urban society, I mean, we are all in the urban area, okay, the noise in I am in urban. So noise in urban society, there inevitably will be. I mean, you can expect this. So anyone living in town must expect to have to put up. I mean, you have to tolerate, you have to bear with a certain volume of noise from his neighbors, and he in turn must have the right to make certain amount of noise. I mean, you need to bear, and you can also make familiar noise. Okay, the same level here in the enjoyment of the property. But then again, okay, the court made it clear, the word there, but, okay, but it is just as clear that no one has the right to create a volume of noise of such intensity, so intense, okay, so high volume, and no one should be asked to put up with such a volume which by any reasonable standard becomes a nuisance. So despite that it is a urban society, but there is certain level of noise which is no longer bearable. Okay, I mean it beyond reasonable standard. So it becomes a nuisance in that situation, like this case. Okay, let's have a look at another case here. Another example, whether this is something which is reasonable or unreasonable interference. This is House of Lords Edition, 1997. The case name is Hunter and Canary Wharf. Here, it relates to interference with TV reception by a tall building. Meaning here, let's say you have a neighbor and the neighbor is very rich. So they build a huge building, a tall building. And it interferes with your TV reception, for example. Can you say it is a nuisance? Actually, by virtue of this case, the court held that no, okay, it could not amount to actionable public or even private nuisance here. Because why? For nuisance, there are limits. So this is the limit. So this is the reason for judgment why the court came or House of Lords came to such a decision or conclusion. There are a few reasons here. The first one, the court said, well, there are limits to what the law considers a protectable interest in land. I mean, you can protect interest for your land, but then there are limits. Okay, you cannot actually stop your neighbors from building or constructing this tall building. So the mere presence of a building, even very tall one, I mean, it's very you are unfortunate or fortunate, okay, to have such a neighbor. So even a very tall one like the Canary Wharf Tower cannot constitute a nuisance simply because it physically obstructs a view or a signal. So it doesn't amount to nuisance here. Because why? The court held that nuisance usually involve something emanating, okay, or produced from the defendant's land. For example, noise, smoke, or smell. So for this tall building, it doesn't really create this noise, smoke, or smell. So in this case, the building was not doing anything active. So it was simply existing in its space. So you cannot stop your neighbor from building such a tall building or huge tower, for example. All right. So I mean, this is an example of interference which is lawful. Okay, it's not unlawful interference. Okay, let's move forward. All right. So, I mean, this is in connection to the case of just now. Hunter and carnivore. Okay, at common law, anyone, even in Malaysia, I think, anyone may build whatever he likes upon his land. You can stop your neighbor from building a bigger house than yours, or a huge, or even very high or taller building than yours here. Okay, so if the effect is to interfere with the light, air, or view of his neighbor, then that is his misfortune. It doesn't amount to actionable nuisance. So the owner's right to build can be restrained only by covenant. Okay, by way of contract or acquisition. This is under land law. Okay, later you learn you have the term prescription, easement. Okay, that one under land law, not really under tort law. I mean, it doesn't amount to unlawful interference here. Okay, we go to the I mean the second element. Okay, just now. Go back to. All right, we were discussing. Okay, we were discussing. I mean, we have just discussed substantial interference, okay, amenity and physical damage. So now we are looking at the second one, which is unreasonable interference. Okay, you have the number 2 there. All right, unreasonable interference. So the rule for this unreasonable interference is that, okay, that's the Latin maxim. Okay, sic iterate tuo. I just pronounce according to the spelling. Alenium non laders. Okay, it means, okay, we go straight to the meaning in English here. Use your own property as not to injure your neighbor's one. I mean, you have the right over your property. You can use your property, but you cannot injure your neighbor by the usage of your property. All right. So again, this is repetition for part one because it's about balancing the interest, competing interest here. So even concept of reasonable or reasonableness or unreasonableness here, I mean, how to say, is it reasonable or is it unreasonable here? So it means balancing the right of both parties, competing rights. Okay, here, maybe plaintiff say, oh, that one unreasonable, but defendant said, no, this is reasonable. So it's competing rights here. So plaintiff has a right to the undisturbed enjoyment of his property. And defendant has a right to use his land in any way he wants. So we need to balance this. Okay. I mean, we need to compromise. Okay. That's the word. Okay, compromise. But that's not the legal term. Okay, so we are looking at the first factor. I mean, it depends whether the court will consider. It depends whether it's relevant or not for that particular situation or facts of the case here. Okay, the first one that the court will look into is extent of harm and nature of locality. Here, this is one of the important factors here because why? When loud noise or even smell or fumes from defendant's land invade the plaintiff land, so in that situation, defendant cannot be said to have used his land reasonably. So we are going to discuss some cases there. Okay, you can see the case of Halsey and Esso Petroleum, Bone and Seal and St. Helens Smelting Company and Tipping. Okay, about this extent of harm and nature of locality here, okay, when it involves physical damage to the land, okay, I mean the word is physical damage, then the court won't bother to look at nature of locality. It doesn't matter whether too far or too near here because why? It involves physical damage. But if it is non-physical damage, okay, for example, the way that you enjoy property, okay, all right. So the court will look at nature of locality because why? It doesn't involve physical damage here. It's just mere I mean, you're not comfortable, okay? Non-comfort here. I mean, it affects with your comfort or amenity. So nature of locality will be taken or may be taken into account. Let's discuss the case. All right. So, again, I mean, this is just to elaborate more. So, given the nature of locality where the plaintiff is residing, now, is he expected to tolerate certain harm here? Okay, what if you are residing or staying near industrial area? Or you're staying near airport, for example, okay? So, is he expected to tolerate certain level of annoyances? Okay, lorries or smell or trading, okay, depending on the nature of your locality. All right, so I mean, this is the case. St. Helens Smelting Company and Tipping, very old case. This is 1865, but decision by House of Lords. UKHL is House of Lords. So here, the claimant, I mean, very wealthy, very rich here. So he owned a manor house, a very large country house, situated a short distance from defendant's copper smelting business. I mean, the maybe certain factory here, all right? So he brought a nuisance action against the defendant. Because why? The activities or business of the defendant here cause damage, okay, due to the smelting works here. So it damage their crops, trees, and foliage. Okay, whatever plant, leaf, as a whole, collectively. And actually, in that area, okay, there were several industrial businesses in that locality. So, including alkali work. Okay, alkali work here. What happened next? All right, now this is argument. Okay, defendant argued that the use of property was reasonable given the locality. And they say, oh, nothing wrong here. Okay, it's reasonable. This is the area, and the smelting work existed before the claimant purchased the property. But the court held that here it involved physical damage to the property, okay, to the trees, to the plants here, right, to the leaf. So when there is physical damage to property, the locality principles has no relevant, and you cannot argue, okay, that the claimant came to the nuisance. Doesn't matter who come first, who come before, who come later. Okay, so long there is nuisance, then I mean, it amounts to actionable nuisance, and the party can take action against the other party. All right. Another important case is Halsey and Esso Petroleum. This is 1961. Halsey, he lived down the road from an Esso Petroleum oil factory. I think in Malaysia, if you are living in area, Kerteh area in Terengganu, all right, you can expect this petroleum industry here. All right. So factories emission produce an offensive smell. So the smell is suspected, and that the acidic residue from factory smoke, I mean, it also produce smoke, emit smoke, damage his linen, okay, clothing, and car paint. And on top of that, okay, he was also kept at night by the noise from the trucks, okay, constantly moving about in the area. I mean, daytime, yes, but even nighttime here. Okay, so the court held that disturbing the neighbor's sleep by noise and vibration, okay, the operation of the business here, okay, and damage to the clothes from acid smarts, yes, this amount to actionable nuisance. So I put the meaning of the word smarts, okay, acid smarts here. Another case, all right, this is an case example of smell. This one example of smell as well. Okay, smell and acidic residue and noise. So here for bone and seal, here it involves smell from neighbor's pig farm. I think in Malaysia also we have a certain area, it has a pig farm. Okay, so smell from neighbor's pig farm invaded plaintiff land. So is it nuisance? Yes, okay, it amounted to nuisance, actionable nuisance, in which you can claim for damages or compensation. Alright, this is for comparison purpose. Okay, it involves radioactive. This one in Malaysia. Okay, Woon Tan Kan disease and seven others, and Asian rare earth, or the acronym is R. This is 1992 case. Okay, here. And if you Google, I Google, and that's the real picture. Okay, of I mean, demonstration. Okay, involving this case. I mean, the company belong to Japanese company. Right. So plaintiff, they sued plaintiff, I mean, a group of people resident in that area, sued defendant, okay, for injunction to restrain the defendant, the company, from operating and continuing to operate its factory. So this company, okay, they were operating a factory which produced dangerous radioactive gases. I mean, the gas was there, okay, but you cannot see actually here. This is something that you cannot see, invisible. Okay, at the High Court, actually, the court agree, yes, there was nuisance. Okay, nuisance was established because why? Citation was something over and above the normal inconvenience. But when the case went up to Supreme Court here, actually, the court said no. Okay, here, the court said that since the appellants were operating under a license, I mean, this is a lawful business, okay, here, granted by a statute which provides for an appropriate remedy. So now plaintiff must convince licensing authority, go and complain to state authority or even local council that the operation of the factory was not in the interest of the public because the danger of radiation to their health. Actually, if you read the full report here, another reason why the case failed at the Supreme Court, because why? There's no damage yet. Okay, when, I mean, there's no health concern, or I mean there's no evidence saying that, oh, radioactive cause this usually is long term. Okay, so for short term there's no damage yet here. So the residents were so worried, so they brought the case to the court. So remember, it's not actionable per se for nuisance. That's why they lost the case, and due to some other reasons here, okay, even though they won at the High Court, but Supreme Court, they lost the case. But still the business was closed later. Okay. All right, so I think we stop here. I'm going to continue part three for this private nuisance because it's a long discussion for private nuisance. So exception is green. All right. I want to stop recording. Where's the cutoff point? All right.